So welcome everybody. Welcome to Hempsons seminar or webinar on Mental Health Act and social and community care. I'll introduce us all in a moment, but I just wanted to say that title is really more about the context that we're talking about, the context in which the care and treatment is provided. So we're not talking about the Mental Health Act in hospital. We're talking about the Mental Health Act outside hospital, and I will probably use the shorthand of community for that. Mental health law is complex, but the good news is that there's not a lot of the actual Mental Health Act that applies in the community. So what we want to do today is we want to cover with you what you need or you want to know about caring for service users who might be, have been subject to the Mental Health Act, and to working with other mental health professionals. I take the view that in this webinar, it's one of those where if we don't tell you anything new and just confirm that you know everything you need to know, that's good. And if we tell you something new, that's also good. So please do, as Heather said, please do use chat to ask questions or suggest topics you would like us to comment on. The slide now shows our planned content, so you can have a quick look and see whether it is likely to cover the points you're interested in. And that brings me to who we are. I'm Stephen Evans, a partner at Hempsons. My colleagues, Rachel Hawkin and Rosie Harding, will be taking part in the webinar and dealing with various aspects, as well as mental health experience. They in particular have experience with the CQC and seeking authorisation for deprivations of liberty in the community, both of which we may be touching on later. So if I start off with where do you go to find a bit of help? The most accessible source of support and assistance in relation to the operation of the Mental Health Act is the Mental Health Act Code of Practice. If you just Google that, you will get links to the document as a PDF. That's on the slide is what it looks like. If you may be more familiar with the Mental Capacity Act Code of Practice, it's the same overall size but thicker. The style of writing is a little bit different. So somebody can't see the slides. I don't know why. I'm sure Heather will be working on that. The style of writing is a bit different. It's written more for professionals than for, if you like, the general public. But it does take you through various parts of the Act and how they should be dealt with. If you want a more in-depth analysis, then the book that I recommend is the Mental Health Act Manual, now in its 27th edition, by Richard Jones. That sets out all the provisions of the Act, section by section, and comments on them. It is a book which is regularly used by mental health professionals, and if you have contact with any mental health professional, it may well be they have a copy that they can show to you if you've not come across it before. I don't particularly recommend going into the Act itself. If you really want, if you want to break the Act down and read it, then use the Mental Health Act Manual. So I'm going to now hand over to my colleague Rachel, who is going to just quickly go through some terminology, roles and responsibilities and some of the teams that work in the community. So thank you, Rachel.
Thanks, Stephen. So yes, we're just going to briefly go over them, but we thought it'd be useful to start with a bit of an acknowledgement of often the variance in terminology that you might come across. So it's often quite interchangeable for patients who might be an inpatient but may not be subject to the Mental Health Act. So if we cover that very quickly, a formal patient under the Mental Health Act is detained and not free to leave, whereas an informal or a voluntary patient are able to agree to remain in hospital. We've also put on the slide here the most commonly used or commonly referenced sections to the Mental Health Act, and some of these might be familiar to you. So Section 2 of the Mental Health Act, this is used to provide time to undertake assessments to find out more about an individual's mental health condition, and you can be sectioned under Section 2 for a maximum of 28 days. So this can't be renewed and it cannot go a day over. A patient might be discharged prior to the expiration of the 28 days, but it cannot exceed that time frame. So moving on then to Section 3, this is where we have a detained patient who's actually receiving treatment under the Mental Health Act. And that's initially up for 6 months, but it can be renewed. When you're looking at the Act itself, as Stephen said, the Act itself is quite tricky to kind of navigate, but if you look at it in terms of sections, if the section number begins in the 30s, then that relates to those who've been diverted from the criminal justice system. And so we have a patient that's deemed to require treatment in hospital rather than the prison. The most commonly used section within this part is Section 37. We've also got Section 136, which is very common in the community, which is for the power of the police to take someone to a safe place of safety. That should be a hospital. It should no longer be police stations. Then we've got Section 17, which is a leave of absence, which we'll talk about a bit further in this webinar. And it covers a leave of absence from hospital covered by the RC. And I'll come on to the RC in the next slide. And finally, we have CTOs. This is a community treatment order, and it allows for the supervised treatment of patients in the community rather than a hospital setting. The benefit of a CTO is that you can have patients more easily recalled should they not comply. So the RC I mentioned briefly before, and this is an approved clinician who is in overall charge of the treatment of the individual. So they'll look at decisions about treatment, reviewing detentions, granting leaves of absence under Section 17. Whilst the RC, responsible clinician, commonly referred to as the RC, has overall responsibility, decisions should still be made in discussion with the MDT. We also have an approved clinician. This would be a mental health professional approved by the Secretary of State. Most commonly, psychiatrists undertake this role. You also have Section 12 doctors. These are individuals who must be approved under Section 12, so they have special experience in the diagnosis or treatment of a mental disorder to have that Section 12 accreditation. You also have AMPs, who are an approved mental health professional. That's often a social worker, and they'll have gone additional training to carry out the duties under the Mental Health Act. You also have a second opinion approved doctor, and they provide a second opinion on a patient's mental health treatment. And here you see a safeguard to review that the treatment being provided is appropriate. Finally, you have hospital managers, and that's the responsibility sitting with them for overseeing the daily operations. And it consists of a panel of individuals, and you might have had reference to hospital managers' hearings. And then lastly, we have the tribunals. So looking here at mental health tribunals, and it's just good to have it in background knowledge. You often have 3 people sitting on a mental health tribunal. So a judge who's legally qualified, a doctor, this is often a psychiatrist, and then a lay person. So we've now moved on to who does what in the community. So this is to really pinpoint the key teams. We've looked at the terminology, we've looked at individuals, now let's talk about the teams operations in the community. CAMS, Children and Adolescent Mental Health Service. So this is where you have a switch over, normally at 18. I'm sure a lot of you on this call will have come across situations where ideally there should be a planned switch over for up to a year before the individual turns 18, but it's a common issue that that's not often the case. So you often find children moving into adolescent mental health services with limited planning. And here we think social care is a really important element in having that continuity of care. You have liaison psychiatry. They work within acute hospitals, predominantly in the emergency department. So if you have patients taken in for mental health or physical issues, they might be put in touch with them, or it might be that a request is made for the liaison psychiatry team to review. We have the intensive home-based treatment team, which as the name suggests, it's for the provision of intensive support in the community, which seeks to avoid an admission. So we can look at that in their roles. Stephen's going to look at that further in the webinar in relation to the mental health bill. And we also have the community mental health teams that provide ongoing mental health support outside of hospital, and single points of access. So in our experience, most mental health trusts have them, and they're called that single point of access. And if we look at it for those providing care from the community's perspective, ideally you'll be aware if a patient who you're caring for has mental health issues, who their SPA is there a specific point of contact? If so, what information should be put across to them to make sure that you can get in touch with the right people? There are also, of course, other specialist teams, for example, learning disability or autism teams that work in the community as well. So that's my whistle-stop tour, and I'll now hand back over to Stephen.
Thank you very much, Rachel. I was just going to say, you'll all realise that all of those teams, that Rachel's just been talking about, are normally referred to by their acronym. So it's normally CAMS, HT, IHBTT. They don't spell it out. And the one that used to get me, I have to say, initially when they started to be introduced, was single point of access is SPA. And I was just, what's SPA? So if you hear those used and you're not familiar with them, that's the idea of sort of covering them. Somebody's just raised, what is a layperson? I'm not necessarily going to deal with all the questions as we go along, but this is an opportunity to do that. A layperson is just, what is meant by that is somebody who is not otherwise specially qualified in a particular area that's relevant to what we're looking at. So in this context of the tribunal, it's somebody who isn't a lawyer and who isn't a doctor, and specifically isn't a psychiatrist. Now, the third person on the tribunal, the lay person, often does have qualifications in, they can be a social worker, for example, and they usually have experience of working in the mental health care and treatment context. So we're not saying that they are ignorant of it all. They're usually very much involved and have a long career in working in the mental health context, but they're not specifically a lawyer or a doctor. As I indicated at the beginning, the shorter answer is not much. The Mental Health Act is primarily directed at the powers to detain, assess and treat people in hospital. It's not really directed at the community. Over the years, it's the Mental Health Act 1983. So while to somebody like me that seems relatively recent, it is getting slightly long in the tooth now, which is why we'll talk about the Mental Health Bill. And anyone who can cast their mind back to 1983 will know that a huge amount of mental health treatment was done in hospital, which is now done in the community. So the Act has slowly evolved, but its primary purpose is still aimed at the, where necessary, the compulsory detention of people in hospital and what you can do for people who are compulsorily detained in hospital. There's not a lot of it that applies directly in the community. One area that is specifically related to the community is guardianship. That comes under Section 7. Guardianship is usually exercised by a representative from the local authority rather than the NHS. It's not often used. I don't come across it. Well, I very, very rarely have ever come across it in 30 years. So, but the guardian does have powers in relation to the individual. They can say where the individual is to reside, and they can apply other conditions, for example, making yourself available for assessment and meeting other professionals, turning up somewhere in order to have treatment. But it does not cover compulsory treatment. The other two ways, I think, primary ways in which within the community context you can come across somebody who is still in some way subject to the Mental Health Act is either under leave of absence, so that's where somebody is currently subject to compulsory detention in hospital, but have been given permission by the responsible clinician to leave hospital. Now, this can often be used to test out a prospective discharge placement. So that's one context in which it may be relatively common to come across it. Leave of absence can be made subject to conditions, such as you will reside at a particular place while you are on leave. It may say that you people need to only be on leave for a certain period of time, and it may be that people, we'll come back to this in a bit more detail, actually need to remain in the custody of their carers. But what it can't do is it can't impose compulsory treatment in the community. The answer is if somebody isn't complying with their treatment, the leave of absence will be rescinded and the individual will have to return to hospital in order to be treated. The other longer term way in which people can still remain somewhat subject to the Act while in the community is a community treatment order, or usually referred to as a CTO. Now, contrary to its name, a community treatment order doesn't actually allow the imposition of treatment in the community. It is really a way in which a patient can be more easily returned to hospital if they are not complying with the care plan when they have been discharged from hospital. The difference between a CTO and leave of absence is that it is more technical to get people back to hospital. You have to issue a recall notice. People have to then attend hospital, and then somebody has to decide, the responsible clinician has to decide whether to revoke the CTO. So they will all have conditions. Frequently, they come with a condition to reside in a particular place. And if in breach, the patient can then be recalled to hospital, consider revocation. They're then made subject again to compulsory detention. Going back to the first few things that Rachel talked about, CTOs can only be imposed on patients who have been subject to longer term detentions. So you can't do a CTO for being on a 2. They must have been on a section 3 or a section 37. There's one or two other ways it can happen, but they're longer term detention treatments. And they are applied, or the original idea was that they would be applied to what used to be referred to as revolving door patients. So patients who, when they take their medication, improve, become quite well, and are perfectly capable of living in the community. But then when they're in the community, they feel well and decide they don't need to take their medication, and they deteriorate again and they need to be readmitted. And those were the specific type of patient that it was originally intended for. There are patients who respond very well to a structure. So they feel as if they have to some extent been told of what they need to do or not do, that enables them to comply with that. Whereas when there's an element of if you don't do this, you'll be back in hospital. So those are the patients they're meant to apply to. They're not uncommon, and you may well come across them for somebody who is being cared for in the community. We're going to come back later to how they fit with potential deprivations of liberty. I am now going to hand over to Rosie, who I believe is going to talk about overlap with the Mental Capacity Act.
Thanks, Stephen. Yes, so I'm going to briefly talk to you about the overlap between the Mental Health Act and the Mental Capacity Act. The overlap, some of you may know, can be very complex in some cases to navigate, so we're going to aim to keep it simple today. So the overlap broadly occurs in two ways. And the first is in respect of care and treatment in the community, which, as Stephen said, the Mental Health Act does not cover the provision of care and treatment in the community. There may be conditions on a community treatment order or a conditional discharge which require a person to, for example, comply with certain treatments. But the response to refusal to comply is usually to consider readmission rather than to authorise you carrying out that treatment anyway. So broadly, care and treatment in the community is provided either with consent if the person has capacity in the relevant domain, or in accordance with the Mental Capacity Act if the person lacks capacity and the care and treatment is instead delivered in their best interests. So if you have a person in your service who is subject to the Mental Health Act, then liaison with the ongoing mental health team involved is going to be vital. If, for example, the person is subject to conditions, then we need to know what they are. We don't want to be in a position where community carers are making decisions in a person's best interests, but they're inadvertently making them breach the conditions by, for example, taking them to a particular place as part of community access, or enabling them to undertake a specific activity which they're not supposed to undertake. So what we're looking for in terms of care and treatment provided by you and your staff in the community is that it aligns with whatever provisions the person is subject to under the Mental Health Act, but also acknowledges that the Mental Health Act is not the basis for the delivery of that care and treatment in the community. In the next slide, we're going to look at the second key area of overlap, which is deprivation of liberty. So I'm sure you're all aware that a deprivation of liberty arises where a person lacks capacity to decide where to live, to receive care and treatment, and where they meet the acid test, in that they're subject to continuous supervision and control and they are not free to leave. So the Mental Health Act cannot impose a deprivation of liberty where a person is subject to a community treatment order, conditional discharge, or guardianship. So none of the conditions attached to those mechanisms can amount to a deprivation of liberty. If you have a resident or you care for a person who's subject to a community treatment order, conditional discharge, or guardianship, and they are deprived of their liberty, then they'll need a standard authorisation in place under Schedule A1 of the Mental Capacity Act to authorise any deprivation of liberty, or alternatively, the Court of Protection might become involved to authorise it instead. There is, though, one exception to the general position that the Mental Health Act can't impose a deprivation of liberty, and that's where a person is placed on Section 17(3) leave, either in the short term or the long term. And the 3 is significant here because Section 17(3) provides that if a person's responsible clinician or RC thinks that it's necessary either for that person or for the protection of others, then he may direct that the person remains in custody during leave. And this is significant because it means that leave which is properly authorised under Section 17(3) may authorise staff at the place the person has been granted leave to stop the person from leaving and or to allow staff to lock them in. So although we're talking about the overlap between the Mental Health Act and the Mental Capacity Act here, it is important to note that Section 17(3) can be used to authorise a person remaining in custody, whether or not they have capacity to make decisions in respect of care and residence. And it's usually the preferred mechanism where the reason for a person remaining in custody is for the protection of others rather than for the protection of themselves, if, for example, in the case of potential reoffending. So the wording of Section 17(3) means that staff of the hospital where the person is detained are automatically authorised to keep the person in custody. And the same is true of staff in a different hospital if there's a condition that the person resides there. But where P is placed on Section 17(3) leave in the community, the staff caring for the person there need written authorisation from the managers of the hospital to keep the person in custody. And if the person's leave is not properly authorised under Section 17(3) in that staff at the placement are not specifically authorised to keep the person in custody, then they're not authorised to prevent the person from leaving. And in some situations, they may only be able to report that the person's breached a condition rather than having an ability to prevent them from doing it. So if you or have anyone placed with you or anyone you care for is on Section 17.3 leave, then do carefully review the paperwork and ensure that, if appropriate and required, your staff have been properly authorised in writing by the managers of the hospital to keep them in custody. Because in our experience, it should be automatic, but can often be overlooked. So I'm going to hand you back to Stephen now to go through some practical points.
Thank you very much, Rosie. It just occurs to me too, there is a lot of background in all of that that's just been covered very carefully by Rosie. So if you do have any questions, do raise them. The one thing that struck me that we hadn't flagged on the slides, which is my fault because I did them, to clarify, is just people might be thinking, well, what if there's a condition to reside somewhere? Isn't that a deprivation of liberty? No, it's not. The courts have said that being required to merely reside in a place isn't in itself a deprivation of liberty. It doesn't imply the person is not free to come and go. It just means that they're not completely free to choose to live somewhere else. But if they wanted to live somewhere else, that could be discussed and arrangements might be made for that to happen. So it in and of itself, that isn't a deprivation of liberty and sort of sneaks under the line of continuous care and control. So I'm just going to talk about some practical points which we hope are helpful. Where the mental health teams, any mental health team, is still involved with one of your service users, it's vital that there's ongoing liaison with them. You need to know, as we've discussed, what any conditions might be on the CTO or leave of absence. You need to know what any medication regime is meant to be. I'll come on to some other specifics, but there are instances where changes can be made by the responsible clinician to the treatment plan that you really need to be aware of. So it's very important to maintain liaison between the different people involved in the care and treatment of the individual. The specific things I think you should know about are things like, what are the most recent risk assessments? If you're going to take on the care of an individual, who has been subject to the Mental Health Act, there is going to be something which is risky. People do not get detained in hospital under the Mental Health Act without having to show that there is some element of risk to themselves or to others. You need to know what that is. You need to know what the current assessment is. You need to know what triggers for risky behaviour may be so that they can be avoided in delivering the care of that individual. Do you know who to contact if you think the risk is increasing? You want to have somebody you can get hold of quickly. It may be that you have to go through a single point of access through the SPA, but have you got the information available for all members of staff involved to be able to rapidly explain to SPA who the person is, what the situation is, what you need to know, and what support you need? There is a good deal of evidence that any risks present can be enhanced in the period immediately following discharge from hospital. It's a big move to go from a hospital back into the community, even into one where people are still being cared for, if you like, full-time in, say, like a care home. But the more the individual is reliant on themselves, the higher the risks. So, care home is one thing, supported living is another. Going back to their own home with carers going in every now and again, that's something else again. So the there is a good deal of evidence that risks, and particularly risks of self-harming behaviour and suicide, are higher in the first weeks after discharge, when people are getting used to coping again. And in particular, if they've been in hospital for quite a long time, the longer they're in hospital, the higher the risks may be. So it's a period in which to be more vigilant, and to be conscious that any changes in behaviour perhaps ought to be reported up and not just be dismissed. And that brings me on to the final point, which is, what are the signs of deterioration? How well, it may be that you've had long-term contact with this individual, but if they're a new service user in your service, you need to know what their ordinary behaviour is and what their behaviour may look like if their mental health is starting to deteriorate again. And you need to raise the alert early, as early as you can, so that other people can come in and can sort of assess that and work with you to decide what the plan then is. So those are things, I think, which ought to be contained in any discharge plan. But my experience has been that there are times, perhaps not the majority of times or anything like that. I mean, Rosie, Rachel and I all suffer from the lawyer's perennial problem that we only see the stuff that's gone wrong. So there will be many times where care plans are carefully thought out, handed over, all that information is available. We see the ones where it hasn't happened. So we can say that there are times it doesn't happen, and it doesn't happen in sufficient detail for everybody to have the information they ought to have. So do ensure and insist on getting that sort of information. These are broader points about practical issues, which I thought it was worth flagging, just in case you hear discussion about them and you're not quite sure what is being talked about, for example. So one directly involved with the Mental Health Act is funding, and Section 117. This is perhaps more something for the managers among you. But if somebody's been on a longer term detention, e.g. Section 3, Section 37, they are entitled to aftercare, which is provided free by the local authority and the relevant ICB. Don't worry about how that actually works. That's a matter for the local authority and the ICB to sort out. It's a joint responsibility, and the Act doesn't say who should pay for what. They are supposed to sort it out. But it is important, if you're running a business, for you to know who's arranging the service, who's paying for the service, what are they paying for? So what's to be covered by Section 117? Because if it comes under 117, then it should be free as far as the service user is concerned. So you shouldn't be charging for things that are covered by 117. That's to be paid for by the local authority and the ICB. But there may be other things that aren't covered, services that you can provide, which are not covered by Section 117, in which case who is funding those? So it's a matter of just checking where your funding is supposed to be coming from. And on the other side, if there are changes in needs, if somebody no longer needs something, or if you think they need something else, then you need to know who you need to go back to in order to say this needs to be changed, this needs to be increased. And the other thing I think was worth mentioning is in relation to the interaction between the Mental Health Act and inquests. Sadly, of course, there is an increased risk of deaths that need reporting to the coroner for people with serious mental health issues. And that means that you might find yourself looking at an inquest. So the coroner's inquiry into the death. Where somebody is still subject to the Mental Health Act, so perhaps they're with you on leave, then there will definitely be an inquest, and it will be with it's very, very likely to be with a jury. There are arguable points about when people are detained, then the coroner has to sit with the jury, unless satisfied the death was natural causes. But there can be a lot of arguments about, when somebody's on Section 17 leave, the coroner will almost certainly sit with the jury. If they're on a CTO, maybe not. If they've been discharged, but only recently, the coroner may exercise a discretion to sit with a jury. So you may be faced with a jury. And that just means that the inquest is probably going to take a bit longer. It's probably going to be a bit more intense as far as your staff are concerned, and so on. There are also arguments that inquest should be looking more in more detail at circumstances. So this is what's called an extended or an Article 2 compliant inquest, Article 2 of the European Convention on Human Rights, the right to life. That is more easily applied where somebody is or has been recently subject to the Mental Health Act, and that means there may be a more extensive inquiry. That doesn't actually, it's not likely to actually mean any substantive difference for your service or your staff in terms of giving evidence. It has some other implications for the nature of the conclusions that the coroner can give. But if you do, you may find yourself looking at an inquest where the Mental Health Act is a part of that. Think about taking legal advice, either if you normally wouldn't for an inquest, or earlier than you might do for another type of inquest. Sorry, I'm just looking back at the questions. Yes, I entirely agree. The policy is now that CMHT teams have to review patients at home within 48 hours, and definitely within a week because of the transition risk that I was talking about. And I'm sure that does happen in the vast majority of cases. Many of the inquests I deal with, it hasn't happened. Again, look out for that. Would Section 117 Aftercare fund adaptations to the individual's tenancy environment if that were needed, for example, someone with, that's a complicated one. The actual adaptations can be covered, but there are other specific funds and provision that mean it sometimes falls outside 117. So it is important for 117 to have a very careful discharge process when all the needs are considered in advance and decisions made as to whether or not it's a 117 service or not. And I think as the people picking up the care in the community, you should be playing a part in that and saying, this is what would be needed, this is what is we're going to need to happen. Is that going to be 117, or is that going to have to be funded in some other way? I'm just going back a bit. What's the definition of reside? Yes, well, got me there. There isn't a specific, that I'm aware of, condition of reside. It's where the person must be based. I think most lawyers would take the view that it means they ought to be coming back there to that place each day. Not necessarily to sleep for 8 hours a day, but it would, in the normal course of living, it would imply that they come back in order to stay overnight. They might be out all day, but that's where home is, if you like. If you did have a patient who was on a condition to reside at a particular place, and they suddenly say to you they wanted to go off at the weekend, or they, to see family or whatever, I think that's something that you probably should raise with the mental health team and just see whether that's something the RC would envisage or have an issue with. So just very quickly on the mental health bill, it's still going through Parliament. There may still be significant changes to the bill. The latest I've heard is that it's likely to be sometime in being implemented, and by that there is some talk about it possibly being 10 years before it's fully implemented, which just seems slightly ridiculous, but given the position that we're in with liberty protection safeguards and the new Mental Capacity Act code of practice, by way of an example, that might be right. But what I would say is that the clear intention of the new bill is to reduce the number of compulsory admissions to hospital. I don't think that's going to mean more voluntary admissions, because I'm not sure the hospitals are going to have the beds to have the voluntary admissions. But it is more likely, in my view, to mean that there will be more people with mental health issues in the community rather than hospital. So where people perhaps currently would go into hospital, the idea is they will be dealt with in the community. There is specific emphasis on that being the case for people with learning disability and autism. That's not at all a bad thing, but my issue is where the services are actually coming from. Query: will there be people in the community with a higher level of acute mental health illness? I think the implication is that there will be. So that's going to mean more pressure on teams like the IHBTTs, intensive home-based treatment teams, and on your staff and your services. So I think that it's worth looking at the bill. It's worth keeping an eye on it as if you're managers of services or owners of services. What do you want to do there? If you wish me to talk about in commercial terms, there's opportunities there as well as potential issues. But what do you want to be involved with at what level? And what, if you're going to take people who may have a higher level of acute illness, what additional training will you need to be looking at for your staff, and what, and so on and so forth. So there are implications for community services. Very well. So I think then we come to questions. There's one that I think I ignored around guardianship. There's a couple of things. People commenting appointeeship's the preferred option if relevant, rather than the use of a guardianship order. What I would say is they're technically aimed at different things. Appointeeship is when somebody can be appointed, usually from the, if it's not a relative, from the local authority, to manage the benefits, the state benefits of an individual who can't manage them for themselves. So that's more about money. It may have the impact of effectively suggesting where somebody needs to live, because you're paying their rent, or you're dealing with their housing benefit on their behalf, or what have you. Guardianship is more about their support in their social circumstances. As I say, I haven't come across it very often at all. I might be wrong. It just may be that it doesn't go wrong, or local authorities who normally their staff are appointed as guardians have their own in-house legal departments, then they turn to those for advice on guardianship. Experiences nothing has happened when they breach the conditions of guardianship, such as e.g. returning. Yes, well, I'm not surprised. I think it is, again, my personal experience is not great, but my impression is it's largely without teeth. It's the threat if you don't the main threat, I imagine, would be, look, if you're not going to comply with guardianship in the community, you're going to find yourself detained in hospital. But it's largely without teeth. There are certain abilities to move people, for example, but I don't think as a regular routine you'd be going out and trying to find people and trying to bring them back, and it might be debatable as to whether that's actually covered. The Mental Health Act itself specifically excludes the taking of substances, either alcohol or drugs, as being a mental disorder. So really, taking substances is obviously a huge problem. It's not one the Mental Health Act itself is designed to tackle. And how you get people to engage is a whole other issue. I'm sorry, I'm not answering that very thoroughly, but there we are. So that brings on to this point. I hope the new bill is going to include those illnesses as a substance misuse induced, as this is on the rise. Right, okay. So the distinction as a lawyer that I draw is the actual taking of substances, or the dependency on substances, is not covered by the Mental Health Act and is not going to be covered by the new Mental Health Act, as far as I'm aware. If the taking of the substances leads to the development of a mental disorder, then that is covered. The most common one I come across for that is, for example, drug-induced psychosis. So people can be detained under the Mental Health Act for a drug-induced psychosis, but it is generally of limited duration. So because it goes as the drugs wear off. So that can result in multiple very short admissions to hospital because the individual becomes dangerous or unsafe for themselves when they are under the influence. But the Act itself doesn't allow for people to be detained in order to be detoxed. If they have some underlying or other mental disorder which allows for their detention, then detox can be an incidental consequence because they're not going to be allowed to take or illicit substances or drink or alcohol while they are detained. But they can't be detained for that purpose. So I think we have, how long will the referral to the authority take to be actioned? I'm not sure what the referral is referred to there. I don't know if it's guardianship or the section 117. I don't know is the short answer. There's no, I don't know how long it takes people to deal with guardianship. Section 117 is something that should be planned as part of the discharge planning. Again, my general commentary would be that not as much attention is paid to which discharge services are covered by Section 117 and which are not, as there should be. And that can lead to confusion later on as to whether something is or is not actually covered by 117, and therefore who should be funding it, who should be paying for it. But it should be part of the discharge process.
Hello. Hi, thank you so much for your talk so far. We've got an inquiry from a client who says they're on a section 3741.
Right.
And they claim that they've been in hospital, they've been in this hospital for several years and there's not been a review, and that they were initially told it would be up to 18 months. But it doesn't seem clear, I mean, we're not an advocacy service, but it doesn't seem clear to us kind of what their rights are in terms of what review they can be up for, or if there's more to the story of not hearing.
Okay, I'm usually very reluctant to comment on a particular case without details. Section 3741 is one of those. So Section 37 is a hospital order. It's a diversion from the criminal justice system, and 41 is what's called a restriction order. So that's an order imposed by the court that the person can't be discharged as easily as they otherwise might be. So they can't be discharged by the responsible clinician, they can't be discharged by the nearest relative, and the section is not, they're not required to renew it in the same way. It just continues while the Section 41 is in force. They can be discharged by the Mental Health Tribunal. The other aspect of it is it needs the permission of, they have to go to the Secretary of State for Justice in order to get permission to do certain things like leave of absence and what have you, or agree to discharge. So they can be discharged by the tribunal, and they should have rights to tribunal hearings. Off the top of my head, I can't confirm to you exactly what those are, but my belief is that there should be the responsibilities on the detaining hospital to ensure that they have opportunities to apply to the tribunal.
Okay, that's really helpful. Thank you so much.
Thank you for that. I was just wondering about, it is a bit hot off the press. It was on, I think it was on BBC News last night, but there's a bit of a move with the Mental Capacity Act. I don't know if you've seen it, about relatives being allowed to ask for a formal mental capacity assessment where that's not taking place. And I think it's based on a recent case where a patient died, a son. So I wondered if there was any sort of, I think somebody's put in a chat actually about training on dolls and things like that, so it might come under that umbrella. I wondered if there'd be any kind of future updates on that, you know, when that becomes more available.
We can certainly have a look at that. I mean, I'm always slightly mystified, and Rosie and Rachel may wish to comment because they deal with a lot of mental capacity acts. I'm always slightly mystified by the phrase formal assessment, because you know, there shouldn't really be that much difference. You know, there are times when people carefully document Mental Capacity Act assessments, and there are times when people don't carefully document. And I think most people, when they talk about formal assessment, they're referring to documenting it, but the questions and the issues to be addressed are exactly the same. Rosie, Rachel, I haven't gone to the BBC News. I confess I'm avoiding the BBC News or any news generally at the moment. But Rosie, Rachel, have you got any comment on that? We can certainly look at it for a topic in future. Yes.
Just to support that, yeah, I've not seen the article, I'll have a look into it. And everything that you said, Stephen, I completely agree with. That's something that we can note for future webinars and topics.
I think it is more about documentation. Yeah, I know certainly coroners look at that, don't they? So yeah, you're right. I think it's like it happened, but you know, the evidence isn't always there. So it's probably more about that, isn't it? Yeah.
The implication to me is, as with many issues, is that there's lack of communication. If you're communicating with the family around, you know, their loved one, and saying this is what we're looking at, this is what we're thinking, this is what we're saying, and of course the Mental Capacity Act requires consultation with you know, family and people interested in P's welfare, then you know, in most cases, I would hope you would avoid the family turning around saying we want a formal Mental Capacity Act assessment, or you would identify that they don't agree with the assessments that are being made and find out why and work your way through it before it gets to the point of a formal request. But of course, there are times when you end up at loggerheads with family members, just because of fundamental differences of view as to what ought to be going on. Thank you very, very much for your attention. It's been lovely talking to you all, and we will hopefully see you again in future.